All right, let's work through this tonight. Let's bring in our think tank. Joining us in Atlanta, Georgia, criminal defense attorney, former prosecutor Sarah Flack is with us. In Milwaukee, Wisconsin, criminal defense attorney Jason Luczak. And in New York, criminal defense attorney Deborah Blum. All right, all-star panel tonight. Sarah, you're in Georgia, so you go first. Let me do this. Let me ask everyone and get a quick response. Does anyone here think that if this father and son was released on bond, that they would be a flight risk here, that they would flee Georgia, go somewhere, and never be seen from again and wouldn't show up for court? Does anyone think that?
No, I highly doubt it, Vinny. Highly doubt it.
Go ahead, Sarah.
I think it's possible. Vinny, just like it's possible in every case. I mean, if somebody's out on bond, the chances of them taking a flight and skipping the country, anybody technically could do it. So it's possible. Is it likely? I doubt it in this case.
All right. Does anyone, and I'll ask you first, Deborah, do you think that this father-son would be a risk to the community, that they might kill someone else or assault someone else in the community?
Well, New York State has had significant bail reform, and I think that New York State has actually gone too far, and many people that don't deserve to be released without bail are released without bail and then reoffend very shortly after they're released. I think that in this particular case, despite the heinous nature of the crime and the fact that it resulted in the death of a man that didn't need to happen, I don't think that these individuals would reoffend. I think that they would have very strict conditions that they'd have to follow, and they would likely follow those conditions.
Sarah, would you be concerned? You're in Georgia. These two get out. This father and son get out. Do you think the public would be in danger?
I do. I was going to call you Your Honor, which may be fitting, but Vinny, I do, because one, it's a very small town. Two, there's a lot of media attention to it. Three, here, they live right there in the community, and because of the media attention, if people are coming to their house protesting, I know there were protests today. Who's to say that these two men? I mean, at the end of the day, the allegation is that they stalked this young man around the neighborhood for minutes on end. I don't know that they would be able to control it if somebody's outside their front yard. If they, want to quote unquote stand your ground, I don't know that these two, based on the allegations here, based on the totality of the circumstances, that they'd be able to control it. I mean, the facts as alleged by the state at this point don't show that they would be. So I would think that they would be a risk, not only to themselves, but to the community.
Jason, we look at these two. Another issue that judges often consider in bond and bail hearings is the history of the defendants. Do they have a criminal history? Have they offended before? And in this case, I don't think either one has a criminal history. Is that an important factor?
Well, I think it is to a certain extent, but there are certain cases where the media attention, the attention in the community is so high that it kind of takes it outside of the scope of the normal things that we consider in bail. And I think that that's probably what's happening here. They can make all these arguments about the employment history, the lack of a criminal record. But at the end of the day, especially the delay in charging in this case, I think the judiciary, the prosecutors are under such scrutiny that I would be very surprised if the judge releases these two out on bail.
All right. We talked a lot about the community. Pastor Darren West is a resident of Brunswick. He's been very involved in all of this and spoke with Court TV today about what is happening down there. Let's take a listen.
Even though we had this tragic thing in our city, our protests were peaceful. There was no violence. There was no destruction of property here in our city. We made it very clear that we were going to protest, but we were going to protest peacefully.
And Deborah, they absolutely have. We've seen that from the beginning in this case. But should that be in the equation for the judge tomorrow, the community's thoughts about the case?
Well, it's whether or not they're a threat to the community. Do they present a risk if they are released? And there's
No. What I'm asking, though, Deborah, is not if they pose a risk. Should the judge put into the equation what the community thinks about the case? What the community...
Well,
Go ahead.
There are a lot of things that judges shouldn't put into their determinations. And as a practicing litigator, I find that they often are unable to keep things out of their judgment that definitely should not come into play. And I mean, no disrespect to the judges that I'm in front of, but it does happen. And I think when something is as high profile as this is, it certainly comes into presence in the case itself and will impact the judge's rulings because it's going to be under such strict scrutiny.
Sarah Flack, what's the history in Georgia? Have you seen a lot of people get bond charged with felony murder?
Absolutely, Your Honor, again, absolutely. I've got a number of clients now that are out on bond for felony murder. The facts are much, much different, and it's a lot harder and a lot higher of a standard, Vinny, but certainly it happens all the time. I mean, Georgia law is clear that murder is not barred from, by itself, getting a bond. It is a bailable offense. If it meets what's called the Ayala factors, which are those 4 factors you went through at the beginning. Are you a flight risk? Are you a risk to reoffend? Are you a danger to yourself or the community? And are you likely to come back to court if you're released on bond? And theoretically, if the judge finds that none of those are issues, I mean, he would technically, both of them would be entitled, or should be at least entitled to a bond. So, do I think that they'll get one? No, absolutely not. I don't think much has changed since the last bond hearing to justify, as in terms of Ayala, to justify a bond at this point. But it's possible.
What did I do? Did I call you the wrong name, Sarah? Did I do that? What did I say?
I don't know, but I've been calling you Your Honor. So, but that's not the wrong name. So.
Wait. One more time. I'm not. Is it Judge Flack now?
Whatever you would like it to be, Vinny. Whatever you would like it to be.
No. Are you a judge? I'm trying to.
I'm not. I am not. Unless
Okay.
you know something I don't know.
Okay. All right. One more issue we have to deal with here, and that's these defendants, the McMichaels, want to depose the homeowner. And this was the home that was under construction in the neighborhood where we saw the videos of Ahmaud Arbery going in and out. And they are concerned regarding his health and whether or not he'll be able to testify. And they want to get on the record the fact that they had these ongoing conversations with him and they were there trying to protect his property. What are your thoughts there, Jason? Do you think that that this deposition should take place, that it should happen now? And how important of a fact would that be in this case if this homeowner does say what they believe he will say, which is, yeah, I had conversations with the McMichaels and I was very concerned about my property down there and I wanted them to keep an eye on it for me?
Well, I think that obviously anytime there's a chance or risk, if it's legitimate, the deposition should probably take place. But at the end of the day, I don't think that evidence is really going to be helpful because, whenever we're talking about state of mind, if they're alleging a self-defense or citizen's arrest, I mean, a lot of that information, and especially whenever you look at what the homeowner was actually going to say, is that he thought Mr. Arbery was just going in there looking for water and didn't commit any crimes. I don't even think it's going to be very helpful to them, especially because of the way in which that video plays out. I think it's so compelling that frankly, I don't think it matters why he was in the neighborhood. Nothing justifies their actions. So, but I would not be surprised if that deposition takes place.
Deborah, do you think a jury or a juror would be somehow swayed by the fact that, hey, these are just a couple of neighbors keeping an eye out for another person from the neighborhood who doesn't live there, who's building a house and trying to make sure that everything's all right?
Well, I agree with Jason. I think that what they're going for here is likely citizen arrest law that would allow the father and son duo to go and do this terrible thing and then somehow justify their actions because they're then going to argue self-defense. So I think here it might be better not to depose this witness because we do know that there were some robberies in the neighborhood. And sometimes when you have too much specificity, it actually doesn't work in your favor. I do also agree, though, that if this individual is somebody that might be sickly or might not be around in 6 months or a year from now, because Georgia right now, I believe, is not actually doing jury trials, you might want to get their testimony, but it could actually work against the defense. But it's also likely that the defense has already spoken with those witnesses or that witness and knows what they're going to cover at deposition, although you can always be surprised what people testify to when you've had the same conversation with them over and over again. I find that sometimes I prepare my clients to testify, and then they'll come out with something very different than they were saying when you practice over and over again. So it could work for the defense. It could lead to further support to these string of robberies and to the fact that that individual told the father, son, the McMichaels, that somebody did this. So they're going to that this was committed in their, well, it wasn't committed in their present, but they had immediate knowledge of it, which is why they were able to get in their car instead of calling 911 and follow Mr. Aubrey around.
All right, when we come back, we're going to talk about the next big trial here on Court TV, gavel-to-gavel coverage of a case out of Ohio that started with a phone call for a pizza. We'll talk about that next.
Have there been any discussions regarding resolution in this matter?
Mr. O'Brien has indicated his client is ready. She wants to go to trial, and she is not interested in pursuing any plea negotiations. I have indicated to him that if that should change and she's willing to accept some responsibility, that we would then start the discussions. And every now and then I'll say any change and he'll say nope. And so we just move on from there.
Attorney O'Brien, is that it?
Yes, Your Honor.
Your client has no interest in resolving this case?
She believes she's innocent, Your Honor. She's convinced of that, and she wishes to go to trial to prove that.
How about that? Sometimes you don't get into that part of a case. You don't get to see what exactly is going on with negotiations, but they're the judge getting it on the record in that call. And we're talking about the next big case here on Court TV. Erica Stefanko is her name, okay? This is a story where she's charged with the murder of her husband's ex-girlfriend, who is also the mother of her husband's child. So I don't know if you followed that. Maybe WEWS, our affiliate from Cleveland, will explain it better. Take a listen.
Exclusive video shows Stefanko handcuffed and heading into the police station shortly after the U.S. Marshals, Northern Ohio Violent Fugitive Task Force, and New Franklin police picked her up following a traffic stop. Detective Michael Hitchings believes Stefanko got away with murder for 7 years until now.
I don't know. I don't know how you could live with that. Yeah, it's something that most of us couldn't think of.
In 2012, 25-year-old Ashley Biggs, who was working as a Domino's delivery driver, was lured to a business on West Turkeyfoot Lake Road after a bogus pizza order. She was ambushed by her former boyfriend, Chad Cobb, who strangled Bibbs and stuffed her body in the back seat of her car, which was abandoned in a Wayne County cornfield. He's serving life in prison. But now Stefanko, who was married to Cobb at the time of the crime, is facing multiple charges. Police say they have new evidence that it was Stefanko who called in the fake pizza order.
And she chose to go along with him on this. She's just as guilty.
Prior to the killing, Biggs and Cobb were locked in a bitter custody dispute over a girl they had together. Ashley's family left devastated by the murder, but relieved a second person has been charged.
The truth is going to come out about, the whole situation.
And the key witness in this case, the key witness against Erica Stefanko, is her now ex-husband, the convicted murderer, who's going to come into court and testify against her. Let's bring back in the think tank. How's that cross-examination going to go, Jason?
Well, first off, what's he getting? Seriously, what is he getting for his testimony? That's the biggest question. And I think, anytime you've got a client who, 7 years after the fact, after this guy's been sitting in prison, who knows what he's cooked up and thought of and what he's talked to. And frankly, it seems a bit sketchy what the new information is, other than this phone call that apparently was overheard where she was making the call. So, outside of that, it's pretty interesting too that, her attorney says, she believes she's innocent. You'd like to be a little bit, I think, more declaratory that she's innocent, if you're her lawyer.
Well, hopefully you won't say that on her behalf. Won't say that in front of the jury. That, ladies and gentlemen, jury, she thinks she's innocent. That would not be a good argument. All right, I get you. Sarah, okay, you've got this convicted murderer coming in. I mean, and me as a former prosecutor, sometimes you have to bring people like that in, but it's not the best case scenario.
It's not, Vinny, but I mean, as you know, as a former prosecutor myself, I mean, the one thing we always say at jury selection or to jurors in closing is we don't get to choose our facts. We don't get to choose our witnesses. I know most states, I believe Ohio included, has a co-conspirator law. So it's interesting to me because generally just a co-conspirator, in his case, he'd be considered a co-conspirator. Just his statement that she was there and participated isn't going to be enough. So that tells me that based on what he said, they went and found some sort of corroboration. And I think we'll find out what that is more specifically down the road. So I think it's not going to just be what he says. I think based on what he said, what he's talked about to the state, they've probably hunted down and verified some of the stuff he's told them, which has corroborated his story. And that's how they've now come to charge her with murder.
And you know what else, Deborah? There are also some jailhouse calls between the couple, and it came up in front of the judge. She had to decide whether or not they're coming in. Let's take a listen.
Is it your position that as jail calls say, and an inmate's looking at it, and they announce it over the audio program that they're being recorded, your position is that subject to spousal privilege?
Until the court rules otherwise, Your Honor, yes.
Okay. This court or another court?
Your court.
Attorney LaPrenzie, what's your position on that?
We agree with the court. The fact that there's no expectation of privacy and it is announced that they are not, that they're being recorded and it's not private.
Okay, those phone calls will come in.
All right, Deborah, we don't know exactly what's on those phone calls, but my guess is it's not good for the defendant.
No, it's probably not helpful. You'd be shocked what people say on those calls, despite the fact that repeatedly, over and over again, you hear someone in the background saying this call is being recorded. So to anyone that might be in jail that's potentially watching this, they should not say things that are going to shoot them in the foot on the calls. I'm not supposed to say that, but logic dictates that. I don't know that you get to use spousal privilege anymore, because I think that only applies when people are actually married, and I don't believe that this couple is married any longer. I think that Erica Stefanko moved on and married somebody else. So I think in general, that is something as a defense attorney I would use against Cobb and say he has every reason to come in here and drag her through the mud because he's upset that she didn't stay by his side while he was serving his life sentence in prison. So anything he says is being said out of spite. But I also agree that, or at least I hope for the state, that they have more evidence to support the charges against this young woman. One of the things we do have to look at is the fact that her arrest is almost 8 years after the victim's death. So you begin to question what kind of evidence they've come up with 8 years later that they're going to be able to show beyond a reasonable doubt, whether it's circumstantial or direct evidence, that this woman was linked to this tragic murder.
Those inmates that you referenced who are watching the program tonight, I'm wondering if they're watching on the Court TV app on their secret phones that they have behind bars.
Vinny, they do. They do have secret phones. It's a thing. I've received messages from former clients, and I'm like, how are you even texting me? You're in jail.
Well, hopefully they have the app. Now, this is really, to me, the heartbreaking part of this, the most heartbreaking part of this story, is that this whole fight between the husband and his ex-girlfriend, it was a custody battle. And they had a girl. She was 7 years old at the time that her mom was murdered by her dad. And now she may be a key witness in all of this. Now she's 15, but back then she was only 7. This argument also in front of the judge.
As it relates to statements made in front of that minor child, Attorney Loprenzi, what is your understanding as to the nature of those statements made by Stefanko to Cobb in general?
She would also be considered the third person in the conversation for Chad Cobb, so that takes it outside of spousal privilege also. The one issue we would have to determine the third person would have to be a competent individual, so you might have to discuss or go through competency with the child, but she's 15 now, and we could discuss that at the time. She made statements to her counselor, I believe, indicating, what she had heard. So we believe for those, that would be the nature of those statements.
Okay. Attorney O'Brien, you haven't filed a motion to exclude her testimony based on competency, have you?
No, Your Honor, but I would like leave to. My argument would be that at the time she supposedly heard these statements, that she was approximately 7 years old.
She was 7. It's 8 years later. She's 15. How important will this testimony be? And could it make the difference here, Sarah?
It absolutely could make the difference, Vinny. I believe in Ohio, as long as she was over 10, there's a presumption that she's competent at the time that she's testifying, and she's over that now. But furthermore, even if she was her young age at the time, I mean, you can go through that as a prosecutor with her to establish to a jury that she understands what's truth and what's not, and that she knows what it means to be honest and to tell the truth from that testimony stand. And at the end of the day, if the jury deems her credible, which I imagine they will, that is going to be the biggest witness for the state, if not the reason that she gets convicted, because that is incredibly damaging.
And Jason, this defense attorney has the job of having to cross-examine her.
Right. Yeah. And I think that what you're going to see is a lot about memory and trying to figure out when exactly this first came forward, because, first line of attack, I think, is obviously that this happened a long time ago, but and why would she remember this? I believe one of the conversations she was remembered the actual conversation where the phone call happened to get the pizza delivery, the fake call. And, why would she remember something like that? Well, obviously, her family was heavily involved, and I'm sure that she probably had some basis to know that that was an important call. And that, maybe she had to, if I were the prosecutor, I'd try to get out the courage that it took to come forward and basically tell this family secret. And I think that's very compelling to a jury.
All right, when we come back, we're going to take you on the docket, the case of a world-renowned robotic surgeon, former German Olympian, charged with the murder of his wife, and they were only married for a few months. That story when we return. On the docket tonight, a case of a very short-lived marriage out of Massachusetts. I mean short-lived. They get married in December, and then the bride is dead by May. And guess who's charged with killing her? Of course, the groom. It's the case of Ingolf Turk in Massachusetts. Julie Grant has more for us.
Robotic-assisted surgery made him famous, but murder charges may make him infamous. Dr. Ingolf Turk was once head of urology at St. Elizabeth's Hospital in Brighton, Massachusetts.
Dr. Ingolf Turk is not your typical surgeon.
This promotional video from 2009 was made by St. E's parent company, Steward Healthcare.
At 6'3" with an athletic physique, it's easy to see why he was once a member of the German Olympic decathlon team.
It showcases the doctor's well-roundedness, his skill in robotic surgery, and its benefits. Fast forward to 2020, that pristine picture has drastically changed. Stewart fired the doctor in February after a scandal involving fraudulent billing. 3 months later, he's behind bars without bond for allegedly killing his wife, Katie McLean. According to police, it was McLean's ex-husband that alerted them on May 15th that she was missing. That day, police found Turk unresponsive at a nearby residence inn. He was revived with Narcan. Officers observing lacerations on his forehead and wrist, cuts on his arms and legs, consistent with walking through brush. The next day, police say Turk confessed to strangling McLean during a heated argument while they were drinking, claiming McLean hit him over the head with an object and he started choking her. Realizing McLean was dead, the doctor reportedly told police he panicked, dumping her body in a nearby pond. According to police and court records, the May 15th incident doesn't appear to be isolated. On December 7th, 2019, McLean alleges she thought she was going to die when Turk choked her and slammed her into their headboard. 1 week later, the couple married in Las Vegas. Then on January 11th, McLean alleges more violence, saying Turk threw her to the ground after asking if she was cheating. A few weeks later, she filed for an abuse prevention order and reported it being violated on February 5th, prompting police to charge Turk. Then on May 2nd, McLean went to court and asked that her civil abuse prevention order be vacated. She asked prosecutors to drop the criminal case as well, but they didn't, and the judge wouldn't adjust Turk's bail conditions to allow him back into the home, but Turk went anyway. Now, all those past allegations may become an integral part of the state's murder case if they attempt to establish a pattern of domestic violence being carried out by the once highly regarded surgeon.
He's 6'3", you know, big guy. And you saw him with his wife, Kate. I mean, she's tiny. I'm wondering, is this guy going to argue self-defense at trial? I mean, he's got some bad facts in his hand, but is he really going to allege that he is the victim here? Let's bring back in our think tank. Deborah, does he strike you as a victim of domestic abuse that was just trying to keep her away, and he had to do what he had to do?
Vinny, I think you make an assumption that many individuals make, that women can't be very vicious. Some women can be very powerful, even if they're very tiny. So it is likely and highly probable that she could have attacked him. I'm not saying that's actually what happened, but to discount the fact that that's a possibility, I strongly caution you against, because sometimes the smallest of women can have very powerful strength. So he could very well possibly argue self-defense. Even somebody that's as skilled as a former Olympian like him could be physically attacked by a woman. That is a very real thing.
I'm just going to let that sit there for just a moment because I'm not buying it. And one of the reasons I'm not buying it is because of the prior history here, Jason. And if that prior history gets in front of this jury, I think they'll have, and I think it should, because they should have a complete picture of what this marriage was like. I mean, a week before they get married, she says that he's threatening her, that he's trying to choke her. A week before they decide to get married, it was one of those volatile relationships where things happen and then they tend to make up. And we've seen victims of domestic abuse, unfortunately, in that cycle. And I would argue that's exactly what happened here.
Yeah, absolutely. I think you're spot on. That's definitely coming into evidence because what you've got is an escalation, which can occur in these domestic violence cases where, the ultimate outcome is very unfortunate, but it's something that does happen. It may not necessarily be common that it escalates to that level, but, frankly, he may try to argue self-defense, but without any sort of weapon or anything in her hands, I think that is a very tough sell because, you've got, it has to be proportional. It has to be reasonable. So, once the threat ends where she hits him with a glass, once that threat ends, it really doesn't justify what happened after that. And he confessed to it.
Absolutely. And Sarah, if he's going to allege that he's getting hit with a glass, and he's going to need some corroboration, won't he? I mean, some maybe a picture or some level of evidence that she in fact did it. Otherwise, who's going to take his word?
Absolutely, Vinny. I mean, he's going to need corroboration. He's going to need to show, on some level, that the fear of the glass, the purported glass, was so great that he feared for his life. And furthermore, most importantly, strangulation is not like a gunshot where you shoot somebody and that's it. Strangulation takes minutes and minutes and minutes and minutes, in most cases, to happen. And so he's going to really have to justify sort of that proportion of his being scared of a glass and then strangling her to death. I don't know that is going to do it, especially with the long history of the cycle of violence that we see in his abuse and her going to the courts and then back and forth and back and forth. I don't think that that's going to do it, Vinny. I would be shocked if he were to be found not guilty on this one.
All right, this last question, I just want to preface it with that I have some amazing doctors that take care of me. As many viewers know, I'm type 1 diabetic. I have incredible doctors who have helped me through this journey. Now, doctors and lawyers, right, don't necessarily see eye to eye all the time. This guy is an Olympic athlete. He's this super, doctor guy, robotic surgeon, whatever. My guess is he's a little bit arrogant, Deborah. What do you think he's going to be like as a client with his life on the line? You think he'll try to run the show?
He's not going to be able to help the fact that he took his wife to a pond where he threw her in. That certainly doesn't help him. I agree that there are a lot of things that are working against him. So he should be fearing for his life and fearing that he's going to spend the rest of his life in jail. So that fact pattern alone generally makes people not the easiest to deal with, because it's very real that this heat of passion argument that ended in his wife's death is going to impact him for the rest of his life. So people fight for their lives in that situation, and it's possible that he's going to try to mitigate and try to strike a deal with the prosecution. Based on the facts here, that's unlikely. So we're going to have to wait and see how this plays out, but it's likely going to lead to a trial because he's unlikely to receive a plea deal, and he's also likely not to be the best client, because he's
my guess is
very intelligent and is going to do his own legal research and then say, why haven't you done this?
Yeah, he's an Olympic athlete, so he had all this adoration through the years, and he was this super doctor. I think he's going to be a tough client, but we'll continue to track it. We've got a pretrial conference coming up on March 4th, and then perhaps we'll get a trial date at that next pretrial conference. When we come back, folks, posted a video today, and it wasn't the crime of the century. It may not even have been a crime at all, but it's Harrisburg police responding to a noise complaint. Things escalate out of control, and I asked you, as the 13th juror, looking at that situation, who's to blame? Why did things end up where they did when it was a very seemingly simple call? We'll talk about that next.
Hello.
Hello, can we help you?
Yeah, we're just getting some noise complaints.
A noise complaint?
Yeah. So
yeah, we can definitely.
So if I can hear it from back there, you just gotta keep it down.
Okay.
Can you just stay a little bit back?
Can you get out my yard?
I have a right to be here. I have a right to ID you. Yes, I do.
You do not.
Yes, I do. Ma'am, I'm not here to cause you guys any issues.
Do not come in my gate.
I hear what you're saying. All I need is your name, and I'm out.
My name is Kamika Campbell.
Can you spell it?
You don't touch people's gates and come into the property without permission. You know that. You know that.
Is she the owner of the property?
It's me, bitch. It's me. Get the out of my gate. Hold on. Let me get his number. Get his badge and his name. Yep, get it. Hoover. Because he's trying to mace me inside my gate. All right. Well, I'm gonna close this door.
No,
and
you're not closing
me.
You
didn't know.
Step out.
Why are you preventing this? Whoa!
Step back.
Why are you touching me?
Graham.
Why are you touching me?
All right. Well, now you're going out to booking.
I don't give a
We will ID you out there.
I don't give a
All right, posted that one from Harrisburg, Pennsylvania, and what a response we got from the 13th juror. Who's to blame for the escalation? How should this be resolved? Let's get right to our 13th juror comment of the day from Alex, who says, the officer was so nice and polite. Must stink to work with people like that regularly. The first girl that received them was also very sweet, and that was literally a done deal. Sarah Flack, what went wrong in this situation?
You know, Vinny, I think that this was a culmination of sort of where we're at in times. I think, police are not very well liked right now, and we can argue about why that is, but I think we're seeing the extent of it. I think we hear a lot of times of police officers demanding respect, and, respectfully, their job is not about respect. Their job is to protect and serve us regardless of how we talk to them. I mean, I'm an attorney. Judges see it all the time. People are not always happy, and so respect really isn't a legal issue. So I just think that, whether or not she was respectful or not doesn't matter. At the end of the day, he was there to protect and serve, and whether she's cursing or not doesn't really play into the equation legally. But I do think, he kept his calm the best he could and charged her, I think, with disorderly conduct, which is a misdemeanor offense. Could have maybe gone worse for her. So I think all in all, he did a pretty good job of de-escalating, all things considered.
Patricia writes, the officer was in the right and the homeowner was in the wrong. I'm not sure she needed to be arrested, but she sure needed to be informed the officer had the right to enter her gate. Jason, who was right, who was wrong in that argument about whether or not he can go in the gate on a noise complaint?
Yeah, I think she's wrong on that account. I think the officer's right. I mean, this situation definitely is definitely a sign of the times that we live in. Where obviously there's a huge amount of police distrust, and it's not surprising that seemingly minor things now, there's so much pent up, anger towards the police that you're going to have situations like this where on the surface, it's why did this become a big deal? But it's a lot more than that.
Shannon tonight, the lady is wrong. She got overexcited about the police officer being on the inside of the gate. If she wouldn't have gotten excited, maybe the officer would have given her a warning and would have been done with the situation. Deborah, do you think it would have played out that way?
Yeah, I think that the officer was just going to issue a warning. Actually in New York City, the police aren't allowed to enter in the way that the police officer is in Pennsylvania. Or at least I didn't see anything preventing a police officer from entering somebody's yard for a noise ordinance citation. And I think he was just going to issue a warning. And unfortunately, this unfolded into an escalation that just did not need to transpire. And I do think that the police officer really was very peaceful. He tried to de-escalate the situation, and the woman became really frustrated and amped up for no reason. I do agree with everybody else that it's a sign of the times, but sometimes I think people just need to think and realize I'm not the one with a gun. I'm not the one that has the power of arrest, and let the police officer run their course. And if I stay calm, that's just going to lead to a better outcome for me, whatever it's going to be. Being arrested is an awful, terrible thing. Then you need somebody like me, but you have to stay calm.
All right.
Most people of color don't have that option. It'd be nice if a lot of us did, but a lot of us don't have that option to be calm and be nice. We've seen that happen with George Floyd, where he was calm and nice, and he was, murdered. So I wish that was the case for all of us.
All right, folks. Great
totally
job tonight.
That,
we are out of time.
Deborah,
we're out of time. I'm so sorry. I'm so sorry. I ran out of time. Don't blame me. Blame the person in my ear. It's their fault. All right. Have a great night, everyone. That's it. All-day coverage tomorrow, the Ahmaud Arbery case right here on your front row seat to justice. Have a wonderful evening, and as always, don't forget to hug the kids.